The state then said, oh, well, that's just fluff. How are you going to actually put some details on it? And the judge said, oh, no problem. The current definition of the word education in Article 9, Section 1 is A, the substantive skills that are specified in the Supreme Court Seattle School District ruling. You know that quote about it's more than reading, writing, and arithmetic. It's the knowledge and skills you need, blah, blah, blah. B, the knowledge and skills in those four numbered provisions of House Bill 1209, you know, the read effectively, write with skill, know and apply core concepts of math, science, civics, et cetera, et cetera. And C, the knowledge and skills that are in the state's essential academic learning requirements. We made a big point at trial that, the state adopted these as essential academic learning requirements, not like suggested academic learning, options or something. They're essential requirements. And the judge said the knowledge and skills in these three things, that is what that word education means. The judge also rejected this idea that basic education and basic program of education are the same. He said basic education and a basic program of education are not synonyms. They are two distinct terms. Basic education is substance, the minimum basic knowledge and skills that are described in this court's ruling, that A, B, and C. A basic program of education, on the other hand, is exactly what it's called, a program that's instituted to deliver that substance. So then on the question of, the court's resolved, paramount, ample, all in education. On the question of whether the state is complying with its constitutional duty under Article 9, Section 1, the answer is no. The state said the state's funding is not ample, it's not stable, and it is not dependable. Local school districts continue to rely on local levies and other non-state resources to supplement state funding for a basic program of education. The court went on. The state has passed legislation, it's ordered countless studies, it has commissioned a multiplicity of reports, and yet there remains one harsh reality. It has not and is not amply and fully funding basic education. And the court went on to note that society will ultimately pay for these students. The state will pay for their education now, or society will pay for them later through unemployment, welfare, or incarceration. The state had their arithmetic equations. We called them arithmetic equations. The state, of course, called them the basic education program, the basic education funding formulas. The state went with our terminology. The arithmetic equation, parentheses, program funding formulas, close parentheses, produce far less than the resources actually required to amply provide for the education of all children in our state. They do not make ample provision for the facilities and services needed to equip all children in our state with the basic knowledge and skills included in the education mandated by Article 9, Section 1. Then with respect to the 2261 excuse, the court had held the state cannot avoid its constitutional violation by stating its intent to comply sometime in the future. A defendant's intent to stop breaking the law in the future does not negate the fact that the defendant is breaking the law now. Now, the court went on, again, because a big defense that the state made is, Judge, trust us, we have a plan. By 2018, we'll take care of it. Judge went on to note that recent legislation addresses but does not resolve the state's perennial underfunding of basic education. 2261 does not require future legislators or governors to do anything. Rather, the legislation is the expressed intent of a current legislature as to what future legislatures should or might do. Without funding, reform legislation is an empty promise. So what did the court actually at the end of the day then order? And I remember I talked about this last time I was here before you. There's this thing called separation of powers. The judge can't actually order the legislature to write a check today. But the court went as far as it could. It said the state, through its legislative and executive bodies, i.e., legislators and governor, you must fulfill your mandate under Article 9, Section 1. And he's laid out very clearly what paramount, ample, all in education mean. The legislature must proceed with real and measurable project to, 1, establish the actual cost of amply providing all Washington children with the education mandated by this court's interpretation. Now, the state's already done that on a lot of things. Transportation, they figured that out. Their own studies show that. On NERCs, their own information shows that. They've already done that on a whole host of areas. And then 2, establish how the state will fully fund that actual cost with stable and dependable state sources. The state must, not can, maybe, sometime in the future, the state must provide stable and dependable funding for such costs, and that funding must be based as closely as reasonably practicable on actual costs. Not the snapshot that was taken back in the late 1970s of what salaries were, or allocations were, or what fuel costs were. Actual costs today. So that's the court's ruling. Next question, the last thing that I wanted to address in my time that's left here is what is going to happen next? Well, remember, just last month, and this is a fuzzy picture, but just last month, every single elected official in our state took an oath. And that oath was, I do hereby affirm that I will uphold the Constitution and laws of the state of Washington. Last month, they all swore that they would obey our Constitution. Last week, the court told them what our Constitution requires with respect to funding of education. And the question is, in these coming days, every single elected official in our state is going to have to look at themselves in the mirror. And they're going to have to ask themselves and answer for themselves. Do I have the courage to do what the Constitution requires, obey the oath that I took? Or am I going to be like those state officials in the southern states after Brown versus Board of Education? The court told them what the Constitution requires, and yet they stalled and delayed for as long as they possibly could. My last slide. This is the speed limit sign outside my son's elementary school. And it's saying that it's a school zone, you have to go 20 miles an hour. And let's just take a situation where, let's say the driver in this car is just an ordinary citizen. And he plows through that speed zone and violates the law. He gets pulled over by a cop. I doubt he would be very successful saying, officer, it's really an inconvenient time for me to obey the law. And it'd be really hard for me to actually go the speed limit right now. So could you let me off? Well, even if the cop gave him a warning, I'm positive it would not fly for him that driver to say, oh, and by the way, it's going to be really hard for me to go the speed limit any day this school year. So I'm going to be blowing through this school zone every day in this school year. And it's going to be really hard for me to do it next year too. So I'm going to blow through it every day next year too. And every day the following year. But trust me, by 2018, I'm going to slow down and start obeying the law. Now, let's change the situation a little. Instead of being an ordinary citizen in the car, let's say it's an elected or a state official driving state government. And instead of being a speed limit sign, let's say it's the Constitution that they have sworn to uphold. The question is, are they going to do, and we're going to have some legislators and some elected officials who say, this is really not a convenient time to be obeying the Constitution. It's going to be really hard to actually comply with the oath that I took. So instead of actually doing something, I'll look busy. And I'll stall, and I'll delay, and hope that maybe some other guy or woman will take care of the problem in the future. You will have other folks who actually do have the courage to stand up and do what our Constitution requires, that do have the courage to actually fund fully education. Because again, as I said before, the state has all the money it needs. They don't have to raise revenue at all to fully fund our public schools, which is their paramount duty. If they need to raise revenue, it's for this other stuff that's not the paramount duty. And the political problem is, of course, kids don't vote. But the people that want the non-paramount stuff, the bridges and the tunnels and other things, they do. That book by John Kennedy, Profiles in Courage, was about people that actually had the courage to do what was right, regardless of the personal sacrifice that it required. And we're going to see in these upcoming days whether we have legislators and elected officials that are going to abide by their oath or are going to try to stall and delay. Now, one